Okay, Shannon, you could put us on the record.
Okay.
This is a matter of Bates and Coble versus Jackson County. Council, state your appearances, please.
Good afternoon, Your Honor. This is Larry Opaleski on behalf of Christine Bader and Sandra Keeble.
Alan Beaverline, Your Honor, on behalf of Jackson County.
So I've read your briefs, gentlemen. I guess the first question I have is, we really don't have a final order certifying a class, do we? If the order certifying has been appealed?
Judge Ludington certified the class, Your Honor. That has been appealed to the Sixth Circuit, but it remains in place currently.
Well, I would assume, since if a timely appeal of that order was granted, that the order's not in effect yet.
Well, it's in effect until the Sixth Circuit says it's not.
So I read the information you submitted regarding complex litigation. I didn't read anything in there that says that although the court is required to create a specific opt-out notice to give class plaintiffs the ability to opt out, that's the only way for someone to opt out. I mean, do you have some authority that says it is the only way?
Well, there has to be a formal notice pursuant to the Federal Rules of Civil Procedure. The Manual of Complex Litigation suggests that there be an official opt-out form so that the courts can keep track. My concern here is this, Your Honor. It's not an unwillingness for the county to pay. It's, I don't want the class counsel of Miller and Ellison and Fox to sue the county again, saying you paid and you shouldn't have because you knew there was a class. I understand, that Mr. Opaleski has a claim that Raffaelli is in effect, but it's also my understanding that Mr. Miller and Mr. Ellison have objected to Mr. Opaleski opting out. As a matter of fact, I told him, I believe it was on this one, I told Mr. Opaleski, I'm willing to pay this claim if you can get Miller and Ellison to agree that they will allow you to opt out. And they refused, I believe. And because of that, and because of my concern that they're somehow going to, when this down the road, sue the county saying, hey, give us our money, you should not have given it to Mr. Opaleski and his clients. That's my concern. I would feel a lot better.
Well, hold on. I see someone else has logged in. Philip Ellison.
Mr. Ellison is one of the attorneys at Fox. I told Mr. Ellison that this hearing would be happening, so he apparently decided to join.
I let him in. So I take it, Mr. Ellison, you're here as an observer. Doesn't sound like he can hear me. Mr. Ellison? He must be having some kind of problems with his settings. I guess we'll hear from him when we hear from him. He's not counsel to any party directly involved. Mr. Ellison, can you hear me?
Mr. Ellison texted me that he's having technical difficulties.
Testing.
There he is.
We can hear you, sir. Can you hear me?
There we go. Judge, I'm sorry.
Okay.
We just switched computers here at my office, and now everything wasn't working right, but now it is. So I apologize. Thank you.
So I take it you're here as an observer?
Well, observer, and to the extent the court would like to hear from me, I just make myself available to discuss the nature of the case, and that I am lead class counsel along with Mr. Miller in the federal action.
Okay, well, I was hearing from Mr. Vanderlaan as to he was reporting to me your position as to whether or not the plaintiffs have properly opted out, or I think ultimately whether they're even able to opt out at this point.
I'd be happy to give my position, Judge, if you'd like me to speak on that.
Mr. Vanderlaan, you were just passing on what Mr. Ellison said.
Yes, I have no objection. Mr. Ellison wants to speak since it's he who I'm most concerned about being sued by.
Go ahead, Mr. Ellison.
All right. Your Honor, the court case that's currently pending before Judge Ludington in the federal court is a fully certified class that has been certified for a substantial amount of time, and it's actually been pending for many years. The problem that exists is for this particular plaintiff in this case is that he is actually already represented by class counsel. Rule 23 and the what's called the Gulf Oil Doctrine provides that cases like this can't be brought by individuals unless the court in the federal court grants permission and authority for the individual plaintiff to bring this action. The reason being they're already subject to the jurisdiction of the federal court. And as a result of that, the current process right now is Judge Ludington, despite our request to have the judge issue notices and allow for the opt-outs, the counties have taken early appeals and have asked for stays, and the federal court has granted those stays. So the delay, if anything, about opting out is a kind of a decision of the trial court judge sitting in federal court deciding how they will administer the Rule 23 class. So as it stands right now, we were not really aware of the plaintiff in this case counsel bringing these sort of actions. We are likely going to have to report this back to Judge Ludington, and he's almost held another plaintiff's lawyer in contempt for these very same actions this way. I don't want to be, I don't mean this to be threatening in any way, but it is once the federal courts have assumed jurisdiction over all these cases, there's no other mechanism in place for state courts to proceed on the same theories or even tangentially due to res judicata and other the subsuming of all those issues before the federal court.
So what I was explaining to Mr. Vanderlaan before you were able to log in is I hadn't really been provided with the authority that you've just asserted, and you haven't referenced specific cases yet, but I hadn't been provided with any authority. I mean, it certainly makes sense to me that if plaintiffs are in fact members of a class that have been certified by a federal court, that it doesn't make sense until they're able to properly opt out of that litigation for them to be able to go forward on a separate front. But I didn't have any case law or court rule that said that. So that's what I'm looking for.
What I can provide you with, Judge, if you would like, would be is I can provide you, and I don't know what the form would be, is whether it would be as an amicus or if you'd like us to formally intervene in this case. But I can supply you with a brief that we dealt with another plaintiff's counsel that has attempted to essentially do the same thing that's occurring here. And that it's the Gulf oil. There's and actually Flint Water just came out with a similar ruling in this matter when the class certification was occurring. Some other attorneys, some plaintiffs' attorneys were trying to rush to the courthouse to be catch the tail end of all of the work that's been done by class counsel to benefit from those. And Judge Levy did not allow that either. I can supply the court with you with that brief, or at least I can draft, or I can redraft you a brief that outlines the legal basis for this about Rule 23 and the communications and the control that a federal judge has with a certified, and frankly, it's actually even a putative class under federal jurisprudence.
So, the representation was that the federal case is stayed pending action by the Sixth Circuit. So despite the stay, the federal district judge is entertaining motions relative to these kinds of issues, notwithstanding the stay?
Frankly, no one's ever asked to take a motion to opt out. That could be one potential way that this particular plaintiff could do so. And then that would be dealt with, through perhaps motion practice with Judge Ludington. Normally, in most instances, and I don't want to, for once, Mr. Vanderlaan and I have been on the opposite side of these cases for many years. I've been litigating these cases for upwards of 5 years now in federal courts and state courts all over the place. The problem that exists right now is that in most instances, a federal court will issue a notice for the ability for certain parties to opt out. Once they opt in or opt out, they have an opt-in, opt-out window. If they don't opt out, they're subject to the outcome of the federal court case, good or bad. Win or lose, you're subject to the outcome of that. Because of the way that this case has been proceeded in federal court, somewhat and I'm going to say it at the behest of Mr. Vanderlaan and his co-counsel on the defense bar, that notice has not been sent out because they've taken early appeals on the stay. As it stands right now is that because it's a certified class, cases like these, and frankly, let me finish the thought, is cases like these have to be abated because the issues are already subject to the jurisdiction of another court. When a class is certified, essentially all the plaintiffs, which would include this plaintiff, has already got a case pending in federal court. This was the same outcome, the same particular outcome of this was required in a case in Tuscola County, where it was called Bandit Car Industries. They tried the same thing to bring their own case, and abatement was the required remedy because, again, they're before the federal court in the Fox case.
Mr. Opalewski? Go ahead.
Yeah. Thank you, Your Honor. With all due respect to my brother counsel here, Mr. Ellison and Mr. Vanderlaan, federal law does not provide that there has to be some sort of specific form in order to opt out. I can provide the court with a bevy of federal case law saying that all you need to do is provide an unequivocal, explicit, timely request for exclusion. That has been the rule for at least 30 years now. That is always going to be the rule as far as I know. And my clients have an absolute due process right to choose who they want representing them and how they want to pursue their remedies. They're willing to give the county a release as to any liability regarding the class action case. And I have no problem with the class action case moving forward, Your Honor. I wish Mr. Ellison and Mr. Miller all the best. We're on the same side of this issue on many fronts. However, class counsel cannot hold class members hostage when they have the absolute right to opt out. I just don't see that anywhere in the case law, and Your Honor is correct. You've not been provided with any. So I'm not sure,
Well, I haven't been provided with any case law by you that says to the contrary either.
Well,
You've recited some, but I didn't see it in what you filed.
Right, Your Honor. We did cite the Phillips Petroleum case that states that we have the absolute right to opt out. I can provide the court with a brief stating that
I know you have the right to opt out at some point. The question is at what point, and what's the process for opting out? That's the very issue in front of me, is it not?
correct, Your Honor. And like I said, I can provide you with that authority. I'm sure Mr. Ellison will have a different take on that.
That's what I need. I need both of you to provide. I mean, I don't want to wade into a quagmire here. If this is an issue that the federal district court has jurisdiction over until such time as there is a proper opt-out, I don't want to wade into that either. So if either one of you can provide me with convincing authority to tell me what I should do here, I'll certainly follow that authority. But so far, I don't see it either way. So let's do that.
Judge, we're happy to, how would you like us to supply that? As just an amicus or, because we're not a party. I mean, it's interesting because essentially this plaintiff has two lawyers. I'm his lawyer and Mr. Opaleski's is his lawyer as well.
You could file it as an amicus brief. That's fine.
Okay, very good.
And then Mr. Opalewski, if you could as well provide me with whatever authority you have. Make sure you copy Mr. Vanderlaan. I understand his position. He doesn't want to get his client stuck with having to pay twice. And I certainly respect that.
Yes, Your Honor. When would you like this by?
You tell me what would be good. I'm not, how much time do you need?
Your Honor, I wouldn't need more than maybe 48 hours. I don't want to compress the court's schedule too much here.
How about 14 days, gentlemen?
That would be better. Thank you.
Thank you.
Okay,
Thanks, Your Honor.
very well. Once I get your supplemental briefs, if I think it's clear enough that I can rule on it, I will rule. If not, I'll have my secretary or court officer contact you, and we'll continue the hearing at a later date.
Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Have a good day, gentlemen.